I can't find the will. Now what? Hi, I'm Neil Tyra. I'm an estate planning attorney in Rockville, Maryland, and I do estate plans for regular folks like you and me. So, sadly, when the time comes and you've lost a loved one in your life and you have to go through the probate process, the Register of Wills, the probate court, will require the original will. Now, what do you do if you can't find it? I mean, why do they want the original will? Well, they want the original will because they want certainty that that, in fact, is the wishes of the decedent. So, one of the things that you can do is when you draft the will, when you execute it, you can store it with the probate court, with the Register of Wills. There's a small fee for doing so, but that guarantees that when the time comes, you're going to have that original will to work with. And it also creates the presumption, the legal presumption, that it is the most valid will, the last valid will and testament. But what if you do? What do you do if you can't find it? Well, you can ask the court to admit a copy of the will to be entered into and probated. But it's a bit of a process. The first thing is that typically it's the person who's nominated as the personal rep or the executor of the estate. It's going to be their responsibility to actually file a petition and ask the court to admit the copy as if it were the original. And you have to assert that you've made a diligent effort to find the original, but unfortunately you cannot. So that, is the first step. But here comes the kicker. You have to get everybody who could benefit from that estate to consent to using the copy as the original. So what does that mean? That means every heir or every legatee, in other words, everyone that would inherit under the laws of intestacy, and rather, everyone who's mentioned in the will, they all have to sign off. It has to be unanimous consent to enter that copy into the process as an original. Why is that important? Well, if the copy of the will is not admitted, well, then you have to go under the laws of intestacy, as if you never wrote the will. And sometimes the results are far different going that route than following what the decedent wished to have done with their estate as defined in their will. So it can create a real problem. So what's the solution? Know where the original is at all times, maybe even file it with the Register of Wills ahead of time. If you need more help with this, I'm Neil Tyra. I do estate planning in Rockville, Maryland. We do estate plans for regular folks like you and me, and all of our information is at the end of this video. We'd be delighted to help you solve this issue. Thank you.